off with that. Actually, try it. Just three. Spike's up there.
Test, test, test. Test, test, test.
Oh, I know, because I'm on delay. I hear everything.
like
Oh my god. So I have my, I can easily move around if I feel like I know exactly what it is.
Andrew.
I have all my court cases. This is my like best in a way. Because it was also easier for me because like I wrote a lot of extra information because when I write it down I remember it, so when I read it I remember it.
Like 2 weeks ago. He just is like, I heard
Oh, that makes sense. But it's like it's currently he wasn't oh my god.
It doesn't have to be boring. Bunch of people's data to find your target and violating like as many positions as yourself because like they don't have it. So just look it up. No, but they might put it
I have too many papers. Three of these were done today, 2 of these yesterday. Do I take another with the same application twice? Or do I take another?
What did you do?
Took it, I did it, and then took that thing. Well, took my best, let's say, let's go.
Welcome, everyone, and thank you for attending the 17th annual session of the Camden Collegiate Supreme Court. My name is Leah Wolke.
My name is Graham Kidd, and we are your hosts for tonight.
To start, we are going to show a video made by Camille LaBelle and Ella Tanagan.
Madam Chief Justice, may it please the court.
Now, Andrew Rob and Mr. Maria, the police can't figure out who did it. They can't see his face, but they can see he's using his cell phone. From that, they figure out and arrest this guy, Jack.
A Fourth Amendment search only occurs when the government violates an expectation of privacy.
Chapter, camera's location voluntarily, nobody had put it on.
While also protecting the privacy and security of all citizens.
Jackson consented to Google sworn insufficient history data by opting into that feature of software.
Searching petitioner's location history was a search of petitioner's property.
Because the government searched through this information in order to find incriminating information, this constitutes a search. And he is watching. My name is Victor Gavin.
Name is Sally Mosey, Ellen Matulski, Caroline Harrison.
Respond respectfully to the question. Petitioner respectfully requests the court to affirm the decision of this court to overturn this
The
decision.
United States Court of Appeals for the Fourth Circuit.
Six student lawyers will be arguing the case of Chattree versus United States to 9 justices tonight. And the case raises Fourth Amendment questions concerning the constitutionality of geofence warrants.
To be selected as one of our lawyers, students have to prepare and deliver a 5-minute argument to AP government teacher Scott McGraw, arguing that Chatree's Fourth Amendment rights were violated. They then came back a week later and argued to Mr. McGraw that Chatree's Fourth Amendment rights were not violated. After that, Mr. McGraw chose these 6 students to present tonight.
Since being chosen, they have gone through hours of practice in front of previous student lawyers, their peers, and practicing attorneys to prepare for tonight's argument. They have put a great deal of time and effort into this activity and will be presenting their final argument tonight.
Now, Michael Hagan and Nihal Nalaparetti will give you a short presentation about the facts of the case and the legal arguments you will hear.
So Michael and I are going to give you guys a little bit of context regarding case facts and potential legal arguments that you might get tonight from our lawyers. So, the Cole Federal Credit Union in Midlothian, Virginia was robbed on May 20th, 2019. And if you didn't know where Midlothian, Virginia is, it's in Chesapeake County, nearby Richmond. The robber had a firearm and forced the manager to open the safe and give him $190 grand in cash. The police couldn't identify the robber from the surveillance footage, but they did notice that the robber used a cell phone. As it turns out, he had his location history turned on.
Later the following month, the identity of the robber was still unresolved, so Detective Joshua Hilton appeared to a magistrate for a geofence warrant requiring Google to turn over anonymized data on cell phone users within 150 meters of the bank. For those of you who don't already know what a geofence warrant is, it is a reverse location search warrant that compels companies, primarily Google, to disclose data on all mobile devices within a specific geographic area during a set time frame.
The warrant included a three-step process. Step one, the Google required to turn over anonymized data to cell phones within 150 meters of credit union for 1 hour. Then they identified 19 users. Step two, Detective Hilton went to Google a second time and got data outside the perimeter and time frame of the original warrants. From the 19 users, they identified 9 of those users. Step three, Detective Hilton went to Google a third time and asked them to de-anonymize the data, and then they identified 3 users.
The geofence warrant led law enforcement to Akello Chatry's house, where the police found $100,000 in cash and was charged with robbery. Some of the pre-trial motions that Chatry sought to exclude all evidence obtained from the geofence warrant, arguing that the warrant violated the Fourth Amendment.
For those who don't know what the Fourth Amendment is the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no one shall issue but upon probable cause, particularly describing the place to be searched and the persons or things to be seized.
2 questions presented from this case: did the obtaining data from Google constitute as a search for the Fourth Amendment? And if so, was that search violating the Fourth Amendment?
So first off, what's the search? People have Fourth Amendment protection over their property and any other material over which they have a legal right to protect their privacy.
A similar case, Carpenter v. U.S., the U.S. government got 27 days of location data from Carpenter using cell service location information. The Supreme Court held this to search be under the Fourth Amendment because Carpenter had reasonable expectation of privacy over his location history.
On the other hand, the third-party doctrine holds that individuals have no Fourth Amendment protection for material that they have voluntarily shared with others. Unlike the defendant in Carpenter, Chatry voluntarily opted in to Google's location history service.
No Supreme Court has directly addressed whether electronic information is property in a Fourth Amendment context. The court has held that property consists of free use, enjoyment, and disposal of a person's acquisitions without control or diminution, save of the law.
In Carpenter, the court included evidence that obtained without probable cause warrants using cell site location information, CSLI for short. The government received 127 days of CSLI from one carrier and 2 days of CSLI from another. The CSLI showed that Carpenter's phone was near 4 robbery locations at the time the robbery occurred. The court held that the government's actions constituted as a search because they revealed specific data regarding his movements over a long period of time and could only be justified by obtaining a probable cause warrant. The court rejected the third-party doctrine, holding that cell phones are an indispensable and pervasive part of their daily life.
If this was a search, was the Fourth Amendment violated? For the Fourth Amendment to be violated, the warrant requires one to be supported by probable cause and particularly describe the place to be searched and the things to be seized. If the geofence warrant fails either of these requirements, it is non-constitutional.
So first off, what are the potential arguments? Okay, Chafee's location history constituted as a search. Petitioner had a reasonable expectation of privacy in his location history. Opting into location history did not cause petitioner to lose its reasonable expectation of privacy over the data. Petitioner's location history is his property.
Even if there was a search, the geofence warrant did not comply with the Fourth Amendment. There was no probable cause. The warrant was not particularized enough to comply with the Fourth Amendment, and even if step 1 of this process was unconstitutional, steps 2 and 3 were not.
Now, for the respondent's argument, the U.S. side, obtaining Chafee's location history did not constitute a search. Chafee had no reasonable expectation of privacy and 2 hours worth of location history. By opting into location history, Chafee voluntarily shared his location history with a third party and lost any expectation of privacy he may have had in it. Chafee's location history is not his property.
Even if there was a search, the geofence warrant complied with the Fourth Amendment. There was probable cause. The warrant was particularized enough to comply with the Fourth Amendment, and all 3 steps of the warrant complied with the Fourth Amendment. That's all. Thank you.
Last week, Jocelyn Urban, Kelly Sharp, and Piper Stroud told upper school students about the use of cell phone location services, and they are now here to present their findings.
Okay, we sent a poll to all of the upper school students with questions related to the Chattree case.
So the questions were about location, reading privacy policies, the benefits of location-based services versus privacy risks, checking or changing application permissions, trusting companies with your location, and the level of concern over law enforcement using your location without your knowledge.
The first question was, do you allow apps or websites to access your location? 49.2% said rarely, 37.4% said often, 8% said never, and small percentages said always and unsure.
The next question was, do you read privacy policies regarding location data? And 59.4% said never, 31.6% said rarely, and other small percentages were of always and often.
The next question was, do you believe the benefits of location-based services outweigh the privacy risks? 51.3% said no, while 48.7% said yes.
The next question was, do you regularly check or change application permissions? And 76.5% responded no, and 23.5% responded yes.
How much do you trust companies to handle your location data responsibly? 49.2% said somewhat, 31% said very little, 10.2% said not at all, and 9.6% said a great deal.
And the last question is, how concerned are you that your location data could be used by law enforcement without your knowledge? 42.8% said not very concerned, 36.4% said somewhat concerned, 11.8% said not concerned at all, and 9.1% said very concerned.
Now it is time to get to the arguments. The lawyers will argue their side of the case in front of the 9 justices for 10 minutes. The justices will interrupt the students with questions about the case, and the students are expected to answer on the spot within the time provided.
First, Caroline Kennison and Ronnie Shaheen, please stand. They will argue on behalf of Commissioner Ocala-Chowdhury.
Second, Isabella Gerald and Rick McGowan, please stand. They will argue on behalf of the respondent of the United States.
Third, Daniela Matilsky, please stand. She will argue as amicus on behalf of the Technology Alliance.
Fourth, Sally Carbone, please stand. She will argue as amicus on behalf of Virginia Law Enforcement Association.
After all the student lawyers have finished their arguments, the justices will then hold a short conference to vote on the cases, and then over the next few weeks, they will write an opinion announcing and explaining their decisions.
During this time, the students will not know who won. They must wait until the opinion is released. The 9 justices in this case are
Chief Justice, the Honorable Pamela E. Hutchins, is a former judge of the Virginia Beach General District Court and is now an adjunct professor at the Marshall White School of Law at the College of William and Mary. She is also the parent of Cape Henry graduates Alexander and Caroline.
Anne Crouch is a Cape Henry senior who was voted best lawyer in last year's program. She plans to attend the University of Virginia as a Jefferson Scholar.
Dr. Christopher Guerin currently serves as Cape Henry's 11th head of school and president. He is also the parent of Cape Henry student Christopher.
Monalisa Holiday practices law at Joynes and Geiges Law Firm. She is also the parent of Cape Henry graduate Josh.
Kevin Keller practices law at Wilcox and Savage PC. He is also the parent of Cape Henry graduate Olivia and Cape Henry student Grayson.
Wendy McGraw practices law at Hunter Andrews Kirk LLP. She is also the wife of Cape Henry AP government teacher Scott and the parent of Cape Henry graduate Matt.
Kevin Sharp practices law at Shapiro Washburn and Sharp PC. His wife Kathleen teaches English in the upper school, and he is the parent of Cape Henry graduates Colin, Cape Henry graduate Nolan, and Cape Henry student Kelly.
Jonathan George teaches AP Computer Science and Principles of Construction in upper school and is also Cape Henry's STEAM director.
Will Trager is the head of the Cape Henry Upper School. He is also the parent of Cape Henry students Owen, Ella, and Lucy. Before we start, one special word of thanks to Chris Souther, Cam Gentry, CHG TV Club for broadcasting, and everyone out there watching on TV.
And now, please rise as Cotton Peak sings the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose bright stripes and bright stars
before the Honorable, the Supreme Court of Cape Henry, are admonished to draw near and give their attention, for the court is now sitting. God save Cape Henry, and God save this Honorable.
Be seated, please. All right, counselors. Ms. Kennison, when you're ready to proceed.
Madam Chief Justice, may it please the court. My name is Caroline Kennison and I am representing petitioner Okello Chaudhry. Petitioner respectfully requests this court to overturn the decision of the United States Court of Appeals for the Fourth Circuit. The court should overturn the lower courts for the following reasons. First, searching petitioner's location history was a search because petitioner had a reasonable expectation of privacy in his whereabouts, similar to Carpenter in the Carpenter versus U.S. case. Second, the third-party doctrine does not apply because location history is not a business record. Rather, as the Supreme Court recognized in Carpenter, it is highly detailed personal information that even when shared with a cell provider remains protected. Finally, searching petitioner's location history was a search of petitioner's property. Data qualifies as protected digital property, similar to one's papers and effects, over which users maintain control and exclusion rights. In Katz v. U.S., the court held that an eavesdropping device placed on a public telephone booth was a search, and concluded that a search occurs when the government infringes on a reasonable expectation of privacy. The police's use of a geofence warrant was a search because the government violated petitioner's reasonable expectation of privacy under the Fourth Amendment, which protects reasonable expectation of privacy against...
Counselor, excuse me, do you have to decide that he had a property interest in the data to find in your favor?
While one of the pieces of evidence is that location history is property, even if it is not property, the petitioner still maintains that reasonable expectation of privacy in his data. Because as the Carpenter Court concluded, all cell phone users have a reasonable expectation of privacy in their cell phone, including location history. In Carpenter, the court concluded that accessing the CSLI or cell site location information data invades the reasonable expectation of privacy in the whole of his physical movements. Location history is more precise than CSLI and is similar to the GPS tracking that was used in Jones. Carpenter also concluded that with enhanced technology that allows the government to encroach on areas normally guarded from public eye, it's important to preserve the degree of privacy against the government that existed when the amendment was created and before technology was created.
Would you agree that this case is different than Carpenter in the amount of data that was accessed?
I would agree that it is different because Carpenter was 127 days of data. However, the amount of time in which the data is collected should not determine whether or not a search occurred, because even a snapshot of information can reveal highly sensitive and detailed, personalized information that is not otherwise shared. And it has been also concluded in the Carpenter Court that they were not able to decide that the time limit of how long
the data was gathered was what pushed them towards creating that decision that Carpenter had a reasonable expectation of privacy in his data, but rather the highly sensitive nature of the data that was obtained through CSLI.
Frank, Carpenter was so much data that they wouldn't want to put together a picture of what he did on a day-to-day basis. That's not the case here, is it?
While it is not the case here, location history information and data is more precise than CSLI data. And while in Carpenter, it may have needed many snapshots of the data to create that picture, with location history data, that picture can be created in a single snapshot, as location history information can share the exact route that you're standing in ability, while CSLI was not able to do that. So with enhancing technology, it's important that we preserve, as I said earlier, the privacy rights that people have from arbitrary invasions of the government that was intended when the Fourth Amendment was created.
Well, let's talk, Council, about something that's not arbitrary, and that's the exercise of the discretion to or not to include yourself in the location tracking history. Is that not an individual discretion that we're free to exercise or choose not to? And in this case, did your client choose?
Yes. While petitioner opted into location history tracking, it is not meaningfully voluntarily. As decided in the Fifth Circuit, enabling location history is made easy on purpose, while removing the data afterwards and unenabling it is purposefully complex and difficult to do.
Counselor, made easy to do. Convenient, but not mandatory, correct?
Correct. However, in Google's privacy warnings, they are limited with how they explain that location history focuses on how the data is used for personalized benefits. It is meant to create personalized maps and recommendations and emphasizes on how it is saved to your account and is meant to remain private to you. Also, with the terms and conditions, it is not reasonable to expect everyone who agrees to fully understand all the terms and conditions if they are not a technological expert. Additionally, even experts have trouble. As said by a Google software engineer, they thought that they had location history turned off, but when they checked, it was enabled. So it cannot be expected.
Who's the they referring to? Your client?
Can you please repeat the question?
You said they had their location device turned on and they didn't realize it. Are you referring to your...
No, I am referring to a Google software engineer who had admitted in a brief that they also don't understand the full length of Google's terms and conditions, so it cannot be expected that individuals without a background in technology can understand the exact meanings of the terms and conditions that even a technological expert does not fully understand. The third-party doctrine also does not apply in this case, as in U.S. v. Miller, where this court recognized the third-party doctrine, which states that a person doesn't have a reasonable expectation of privacy over information that they voluntarily give to a third party. However, this does not apply here. While in Miller, it was concluded that canceled checks were business records of the bank, location history is not a business record. It has been said by Google that location history is not a business record, but rather a travel journal that is created for the benefit of Google users. A business record is a document maintained by an organization that is essential for operation. Additionally, location history data is not essential for Google service operation.
Now, does Google use the information for any of its own business purposes?
No. Or Google does not disclose that they share or use that information for their own purposes, but rather for the purposes of the user, and they emphasize that the data is private data that is stored only in your account simply for the user's benefit. However, even if location history was a business record, Carpenter establishes that the doctrine does not apply. In Carpenter, CSLI records were business records. However, the court declined to apply apply the third-party doctrine because the extensive chronicle of location information that is collected by wireless carriers, even if held by a third party, deserves Fourth Amendment protection. And location history is even more precise and detailed than CSLI. So it has even more of a reason to not apply for the third-party doctrine and have that reasonable expectation of privacy. Lastly, even if petitioner didn't have a reasonable expectation of privacy, which he does, it was still a search because location history is private data stored in private accounts on Google servers. The court considers such data as a form of property, similar to one's papers and effects that deserve Fourth Amendment protection. The attributes of property is the right to use, enjoy, dispose, and exclude. Google users may freely use, enjoy, and dispose of their location history data, as well as exclude others from seeing it, as it is stored in password-protected accounts and inaccessible to others. Google has said that location history is similar to documents on Google Docs and emails in Gmail, which both have been confirmed by Google to be a user's property. So similarly, location history data should be a user's private property that deserves Fourth Amendment protection. Given that many attributes used to describe property are used to describe location history, courts and legislatures alike, for the foregoing reasons, petitioner respectfully requests this court to overturn the decision of the United States Court of Appeals for the Fourth Circuit.
Thank you, Ms. Hanson.
Counsel, are you ready to proceed? Gerald?
Madam Chief Justice, may it please the court, my name is Isabella Gerald, and I am representing the respondent of the United States. Respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the Fourth Circuit that a search did not occur when the police used a geofence warrant to identify Mr. Chaudhry, which ultimately led to his arrest. A Fourth Amendment search only occurs when the government violates a reasonable expectation of privacy. Here, there is no reasonable expectation of privacy for two core reasons. First, the data was voluntarily shared and given to Google by Chaudhry, which then initiated the third-party doctrine. Secondly, with how the data was collected, no repeated patterns could be identified within the limited scope of time and geographics. So focusing in on how this is voluntary disclosure, in Smith v. Maryland, the Supreme Court held that users assume a risk when sharing information to a third party, such as Google, and they lose any reasonable expectation of privacy over that information. And any assumption that that information would remain confidential is subjective and non-controlling. Here, Chaudhry voluntarily chose to share his location data with Google, making it third-party disclosure. Building on that, Google location history data is completely optional, and users must opt in. And to opt in, they must scroll through.
Counsel, so just if you could clarify for us, so if he had not voluntarily chosen to opt in, would it be a search?
It would then be a search if he had not opted in. However, this data was only able to be given to the legal forces because he opted in. If he had not opted in, then this wouldn't be happening at all, as Google would not have been able to track his data with his given permission. As when users, before they opt in, they have to scroll through the entirety of the terms and conditions. And when users press that they opt in and agree to the terms and conditions, it is under the legal premise that they have read the entirety of said terms and conditions. As the Fourth Amendment,
My concern with this technology is that most people don't know how to utilize it. They don't know that these terms exist. They don't know how to get there. They don't know how to waive them. Can you speak to that concern, please?
yes. So even after users opt in, they still retain the ability to opt out or delete and edit their history, meaning it's still user-driven and user-affirmative that it is tracked. And from that point, we can see that only 2/3 of users even opt in. So only 2/3 of Google's 5 billion users choose to opt in for this data to be tracked in the first place. Meaning that this is...
One of my
concerns is that people must effectively share their location data, whether you opt in or not, to use these basic modern services. It's almost a requirement to use a cell phone. Is it really a meaningful voluntary choice, or is it more like being, forced to use roads and then being surveilled?
It actually is, as there is some confusion, as when you opt into Google location history data to be tracked, that is merely for additional location-based services. Google and its other applications, such as Google Maps, are still functionable without having that opt-in to the data being tracked, which is seen by 2/3 of Google users not opting in and still being able to use Google and its other applications. And if we compare this to sensitive financial records, which can track where and when someone was, even those do not guarantee privacy once they are disclosed to a third party. So moving on to how, once this information was given to Google, it fell under the third-party doctrine. In this case, all the users whose data Google combed through in order to find the culprit had opted into the tracking. Thus, third-party doctrine does apply. And building on this precedent, we can look at the size of the database. As Petitioner has brought up the size of the database, bringing up concerns or privacy concerns for the rest of Google's users. In U.S. v. Miller, we can recognize that banks routinely have to go through their bank records in order to find or data that must comply with a subpoena. Here, this is still not found to be a search. We can see through that the size of Google's database does not have any recognition that it would be labeled as a search if needed to go through the database in order to find a culprit.
Counselor, does it matter that Google has said it doesn't consider this data to be its business record?
It does matter, as although Google does claim such, the way the data is stored and organized and filed by Google, and furthermore, it is used as a business record by Google for a few purposes. So other than storing and organizing the data, Google as well uses that data for ads and analytics. It uses that in a way where it will see if users are going to advertised locations. And furthermore, it can give those analytics to those advertised locations. This is within Google's policy that they are able to give undefinable or information that would not identify a person to others.
Counselor, you argued previously that the information was not sufficient to prove culpability. Are you claiming that information cannot be obtained unconstitutionally if it is not useful to the case?
Sorry, can you repeat the question?
You argued previously that the information was not significant enough to prove culpability. So are you arguing that if the information is not useful to the investigator in the case, that it cannot be obtained unconstitutionally?
I would say to that this data, with the limited scope in both time and geographics, with how it was obtained, as it was relevant to the case, it still wasn't enough information within that limited scope of time and geographics to have any real warrant of an exploitation of privacy, as that data can only reveal so much. It cannot reveal a detailed encyclopedic pattern of one's life events, such as in the case of Carpenter, where that data, over the period of 127 days, was able to do so. Within a 2-hour period, it is not reasonable to say that a part of location of part of a repeated pattern of petitioner was able to be identified.
Let me interrupt you briefly. Does it have to be a pattern, or does the person have a reasonable expectation of privacy as to where they're standing in this world?
It does matter, and there's been a precedent that within Carpenter, that is with your repeated patterns, there is an expectation of privacy, as that is included within your detailed chronicle of one's life events, which does warrant an expectation of privacy.
How about as to one single location? Is it an expectation?
There is no real expectation, as, for example, we will look at what happened in the case. Before Chowdhury went to rob the bank, he went to stop at a church in preparation for the robbery. Now, let's focus in that Chowdhury did not religiously attend this church, and a church would be part of your religious practices, something that would warrant an expectation of privacy. However, within this one snapshot of time, it cannot be confirmed that this is a part of his repeated patterns. So even if Chowdhury were to have gone to any location that is within the matters of his private matters that relates to his political, sexual relationships, or his overall business, it cannot be confirmed within that short of a time frame that that is part of his repeated patterns and thus warrants an expectation of privacy. So even if,
Counselor, taking the argument that you just made,
yes,
despite the fact that many humans, our lives are dictated in large part by the small funds that we choose to carry around or not to carry around, there is still the freedom of each individual not to have their phone on their person when they're traveling to their church, to their doctor, these examples that you noted. Is that not true?
That is
We
true.
still have discretion in this world
yes,
to carry or not to carry, do we not?
we do. However, I will just add that Google location history data is not directly linked to your phone. It is directly linked to your Google account. It's not linked to a personal device, although it does use your personal device to gain that information of data of your location. It is still directly linked to your Google account.
Well, just as you argue that there was the opting in by the individual for this location tracking, there's also the opting in or out of the maintenance of the vehicle, correct?
Correct.
Yes. And in this particular case, do you draw a line between any of the 3 attempts made by the detective to gain access to this Google information?
There's no line drawn, as in step 1, when Google was compelled to find users that met the requirement of being within the 150-meter radius of bank hour period. All those 19 users that were found to meet that requirement all opted in and all remained anonymized. In step 2, when they extended the time period as well as geographics, that was done through the approval of a magistrate, and it was still carefully done so that the scope of information that could be obtained would not violate anybody's expectation of privacy or information. And in step 3, when all 3 users were de-anonymized, it still lays the fact that all 3 users, and all users who Google's data come through, all opted in for that data to be tracked in the first place.
So in your mind, the 3 stages are not dispositive in any way? All 3 are in the broad net that you're casting?
Yes, as through its limited scope, no reasonable expectation of privacy can be had. Oh, is that time up? Okay. For the foregoing reasons, respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the 4th Circuit.
Thank you, Counselor. Whenever you're ready to proceed.
Madam Chief Justice, may it please the court. My name is Daniela Matilski, and I am representing the Technology Alliance as amicus in support of petitioner Okello Chalker. Technology Alliance is a statewide nonprofit organization with the goal of advancing education and research through the use of technology, while also protecting the privacy and security of all Americans. The geofence warrant used in Chaudhry's case is an example of a reverse warrant in which law enforcement officers used Google location history to obtain location information on individuals within a specific location and a specific time frame. Reverse warrants bring up significant privacy concerns. First, agreeing to share location history is hardly ever voluntary. Terms of service agreements are non-negotiable, meaning that users must accept them or be completely denied certain services. As a result, most individuals click agree without reading the policies. A 2019 study concluded that only 9% of users read the entirety of privacy policies. Of those 9%, only 8% have claimed that they fully understand them. Reading each and every digital platform's terms of service will take an estimated 30.5 workdays to complete, making meaningful consent unrealistic. Additionally, privacy policies are written by corporate attorneys with the purpose of protecting the company, not its users. Hence, terms of service agreements are written with advanced diction and cryptic legal terms that are impossible for a non-professional to understand. Even tech employees get confused when it comes to setting up their own location history. For example, one Google software engineer testified, "I thought I had location tracking turned off my phone. However, the location toggle was on. If even Google engineers struggle with the process, surely the average person will as well. Now, some may argue that users can change their data collection settings or completely turn them off. However, most users will not feel the need to do so because Google advertises the collection of location data as a process used simply to improve the functionality of their platforms. For example, users must turn on location history for Google Maps in order for the platform to save previously searched addresses. Having Maps remember specific addresses saves users time and energy because they don't have to memorize every address or retype them into the search engine. Second, geofence warrants promote tunnel vision within law enforcement because officers hone in on a specific group of people, which causes them to completely ignore other suspects. For example, in 2018, Avondale police used faulty Google location data to arrest Jorge Molina for the murder of Joseph Knight. Despite conflicting evidence and more probable suspects, law enforcement developed tunnel vision, causing them to focus Molina and completely ignore obvious signs that the data was unreliable. Not only did Molina suffer through 6 days in a high-security prison, but after his innocence was proven, the publicity of his arrest proceeded to ruin his reputation. After being released from jail, Molina was fired from his job and was unable to get a new one since a quick Google search showed employers that he had been accused of murder. Molina's case highlights how faulty location data can lead to severe investigational mistakes and wrongful convictions that have the power to ruin an innocent person's life and reputation. Lastly, not only will the ruling in this case impact Chauty's future, but it will also impact the future for all reverse warrants and how they will be used to prosecute Americans. For example, if the court decides that geofence warrants are constitutional, will law enforcement be able to arrest someone solely on a person's proximity to a location? If law enforcement begins to arrest individuals based on suspicion of location, countless innocent Americans, like Jorge Molina, will be arrested and jailed because judges will treat location data as credible evidence despite its many flaws. And if geofence warrants are constitutional, could law enforcement obtain a warrant for the identity of anyone who searched a particular controversial topic, for the identity of anyone who watched a certain video on TikTok? Because of the dramatic impact on personal privacy that arises from the use of geofence warrants, amicus respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Fourth Circuit. Thank you.
Thank you very much. All right, counsel, are you ready to proceed?
Madam Chief Justice, may it please the court. My name is Ron Shaheen, and I am representing the petitioner, Okello Chauty. Petitioner respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Fourth Circuit. The geofence warrant in question is comprised of 3 steps. Step 1. The government asked Google for anonymized data of all users within a 150-meter radius of the bank within an hour of the bank run. This turned out to be 19 accounts. Step 2. The government asked for more information on 9 of those 19 accounts. Step 3. The government asked Google to de-anonymize 3 of these accounts, one of whose was Okello Chauty. The geofence warrant is unconstitutional because it lacked the probable cause it needed for each of the 19 accounts in Step 1, and was not properly particularized as it did not adequately describe which accounts to be searched and which accounts to be further investigated in Steps 2 and 3. First, the government needed probable cause for each individual account to search the accounts in Step 1. As determined in Carpenter v. U.S., users have a significant expectation of privacy when it comes to their location data. Thus, the government going through this data needs to search, and so they need probable cause. But because each account is completely individual, the government needs probable cause for each individual account. It cannot aggregate this probable cause among many different accounts.
Can I interrupt you briefly? I'm a little confused as to kind of the fruit of the poisonous tree doctrine with the inadmissible evidence or the lack of probable cause. You seem to be arguing that if you lack probable cause as to others, not even your client here, right? Others, that's effective to quash the warrant against your client?
Yes, because this warrant is unconstitutional, because Chaudhry was searched in step 3 only because one of his accounts was searched in step 1, which was unconstitutional because they did not have probable cause for each of the accounts.
Was there probable cause at any point? Like, would you concede that once you narrowed it down to 3, the government narrowed it down to 3 persons? I assume there's a specific location in the bank, right?
Yes, but this probable cause was never signed off by a judge. The only warrant signed was before any of these accounts were even determined, before you even knew those 19 accounts at all. So, because those never probable cause signed and a warrant signed by a judge, there was never probable cause to search Okello Chaudhry.
For the entire draft that was.
Yes, for the entire draft.
Thank you.
This, back to the original point, this independence does have precedent in case law. In the case of Maryland v. Garrison, the court ruled that a warrant must have probable cause for each apartment in an apartment complex, not just the apartment complex as a whole, because each apartment has their own individualized probable cause because they are all individual. Thus, the government needed probable cause for each individual account.
Is it your position that a geofence warrant could then never be constitutional?
It would be very difficult for a geofence warrant to be constitutional because it requires that there's probable cause that every single person within the geofence warrant is in some way connected to the crime at hand. The government did not have probable cause for each individual account.
Counsel, going off what you just said about geofence warrants being typically unconstitutional, wouldn't you agree that that puts us in danger of not allowing other types of searches of databases that police often use, such as phone records or bank records, things of that nature?
Just because protecting the Fourth Amendment rights of citizens hampers police investigations does not mean that we should rule in favor of letting these searches slide. The Fourth Amendment protects citizens over protecting the interest of the government to solve these crimes.
Counselor, on that, the government to solve these crimes. In this particular case, as you informatively notified us, it was within 150 meters of the bank, and it was within 1 hour of the perpetration of the robbery. That was the net that was being cast, correct?
Correct.
And the suspect involved was seen with a cell phone.
Correct.
Right. Is there a tightening of that if it was only 50 meters and it was 30 minutes from when the teller said she looked down the barrel of the gun? Would that suggest to you that the probable cause was sufficient, that the net is pulled so tight to the actual perpetration of the crime, then it is probable cause searching tool?
No, because unless you get a net that only includes one person, then it is very likely that many of these people in the net will not be related to the crime. And also, you're only looking at proximity to a crime. But as ruled in Ybarra v. Illinois, mere proximity is not enough to justify probable cause.
Well, Counselor, it's an investigative tool, such as lifting fingerprints from a place that maybe many have touched, correct? In hopes of gathering a piece of evidence that will contribute to solving the crime.
Yes, but this is fundamentally different because users have an expectation of privacy when it comes to their location data. They do not have an expectation of privacy when it comes to their fingerprints.
So, Counselor, you're limiting the investigation that in fact only one person was involved in the robbery? And it couldn't have been a scenario with co-defendants, one posted outside, one in a getaway car, one at the door with the phone. You're making a decision that the investigation had to be limited to only one person to satisfy the requirement?
No, but because there's a significant chance that there is only one person, and there's a very significant chance that within whatever radius you have of the geofence warrant, you're going to include people that are completely unrelated to the crime, because you're only looking at proximity.
So I think it's important that this is really important. I think we're all sort of on the same line here. So what would the government have to do in order to make a geofence warrant stick?
The government would have to have the names already determined and ask Google directly for information of these users. Instead of determining we have this location.
So if the government gave names to Google, is there a limit on the number of names? Could they ask for 10 names, 100 names, 200 names?
As long as they have probable cause for each name that this will help the investigation, then there's no limit besides that.
So in terms of solving the crime, the identity tool aspect of it, under your argument, is totally thwarted. We've got to know the name of the suspect, and then we're going to ask for their location information?
Or some other identifying information.
All right.
Furthermore, this warrant also fails the particularity requirement of the Fourth Amendment. There is no description beyond just the accounts are within this geofence warrant boundary to determine which accounts should be searched. But it already requires us to look into the account in order to determine if they are within the geofence warrant's location. But if it already takes a search to look through the accounts to determine if it's eligible for a search, then this is not sufficiently particular. Furthermore, steps 2 and 3 do not satisfy the particularity requirement, as there is no guidance to which accounts the government should gather more information in steps 2 and 3. It is purely up to discretion of the investigator, and there is no judge to sign off a warrant. So steps 2 and 3 are also not sufficiently particularized. Respondent will argue that the government searched the third-party location Google, which is allowed under Zurcher v. Stanford data, and search the contents of the data found within Google justified by Ross v. US. Petitioner disagrees with this framing. Both Zurcher and Ross need a unified location, like a journalist hub or a car, in order to satisfy their results. But Google is a collection of independent, separate digital effects. Similarly, having Google as a single location to be searched will have some dangerous precedents, such as letting one warrant give the government access to every single account within Google's database, because Google's database is a single location under the respondent's argument. This is inconsistent with acts such as the Stored Communications Act, which requires the government to have one piece of data, one piece of communication in mind to search. For the foregoing reasons, petitioner respectfully requests this court to overturn the decision of the U.S. Court of Appeals for the Fourth Circuit.
Thank you. Counselor, whenever you're ready.
Madam Chief Justice, may it please the court, my name is Vikram Gowdy, and I am representing the Respondent, United States. Respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for two reasons. One, the geofence warrant obtained to search Google's location data satisfied both the probable cause, and particularity requirements for searches under the Fourth Amendment. And two, the search remained valid throughout all three steps, which were explicitly detailed within the warrant. To begin, the geofence warrant obtained by Joshua Hilton had probable cause and was particular enough to be constitutionally valid. The purpose of a constitutionally valid warrant is to particularly describe the place to be searched and the person or things to be seized. This warrant did so, specifying the request for information about location data on computer servers maintained or controlled by Google regarding the specific radius and time intervals surrounding the crime. Moreover, a warrant should be based on fair probability that contraband or evidence of a crime will be found in a particular place, a requirement set forth by this court's ruling in Illinois v. Gates. When investigating a crime that took place at a credit union with an unknown perpetrator, data surrounding people near the credit union around the time of the crime surely has a fair probability of providing evidence to solve the crime. Google servers were also very likely to store such information. Since the demands note in the robbery said, quote, "boys on the lookout outside," petitioner's suggestion that this crime was limited to one single defendant is false. The presence of accomplices or witnesses meant that location data could further narrow down the perpetrator or perpetrators involved. Additionally,
Let me just interrupt you right there. The warrant swept up location data of every person within 150 meters. That included people in a church, in nearby homes who had nothing to do with this crime. How is that not exactly the kind of general warrant that the Fourth Amendment was written to protect against?
All of these people opted explicitly into Google's location sharing. All of these people, according to Google's affidavits, not only had to enable location history on their mobile device, but also on their Google account.
But traditional warrants require probable cause tied to a specific person. This warrant targets no one in particular. It's just casting a wide net hoping to find someone. How does that satisfy?
The issue is, this court has also maintained in Zerker v. Stanford that searches do not require a specific suspect to be enumerated. For the court to maintain that a specific suspect is required for a geofence warrant renders the idea of a geofence warrant useless. Because a geofence warrant is designed to find certain people who have committed crimes within geolocation radii, and to suggest that we would need to find the perpetrators before we can search the radii renders that set useless.
So are all warrants like this okay then, in your opinion?
No, the warrants would have to be specific enough to specify where they would get the data, that being Google servers, and also specifically which data they would want.
Well, let's talk about which data, if we could, for a moment, Counselor. In your particular case, it was 150 meters in 1 hour. Well, that was the first net that was cast down. Where would you draw the line? A half a mile? 2 hours? 3? Where you're arguing this one particular case, but the premise of your argument would be enormously expansive and impactful. If we all sign up for location and we just open the door and no specificity is needed, where do we draw the line?
The issue here is partially that the 150-meter radius helps to include the outskirts of the bank and the parking lot, which were necessary to pick up the area in which the accomplices would have been. Furthermore, within Virginia Code 19.270-70.3, it states that to obtain a warrant for such information, an affidavit by the person seeking the warrant shall state belief that the records requested are actually or constructively possessed by a corporation providing electronic communication services, and the magistrate should find probable cause for this belief. Within the warrant, Detective Hilton stated explicitly, the affiant knows that Google maintains certain records, and when properly served with a legal request, they will provide law enforcement with the records.
So my question to you is not the maintenance of the records. Google has the record. The question is where, in this particular case, again, it's 150 meters in 1 hour. Are we distance specific? Is the operative language the time? With 2 hours, with 24 hours? Might the person have hidden out and not actually left the scene of the crime? And so the issue is that what you're asking this court to agree to, the court is asking you for a degree of specificity as to where we would finally draw the line. When is it too broad, either in proximity or in time?
The court cannot draw a specific numerical line for specificity to define the constitutionality, because were that to be applied in other circumstances with separate scopes, it would be frankly infeasible. However, 2 hours of location data does not provide, as respondent has previously stated, a clear and encyclopedic knowledge.
So can you just tell us then, when would a geofence warrant be unconstitutional?
When, as ruled in Baltimore v. Beautiful Struggle, that the location data provided could create a detailed and encyclopedic record of a person's habits and continuous repeated movements, which in this case is not true. 2 hours worth of location data does not provide the 127 days worth of Carpenter or 40 days worth in Beautiful Struggle of a detailed and encyclopedic record of how that person moves.
Counselor, at what point does the data become encyclopedic?
When it can create a list of habits. That, again, just like with the distance, a clear dividing line with a numerical value cannot be drawn for across the board. However, in this case, it is safe to say that 2 hours worth does not provide a detailed and encyclopedic record. And furthermore, the 2 hours was only for those in step 2 who had been selected by the government and narrowed from the first step. This narrowing was explicitly provided for in the warrant signed by the magistrate, and they narrowed more than half of the records before requesting that extra 30 minutes on each side.
Also, regarding the data that is obtained through these geofence warrants, are there any constitutional remedies or protections for innocent citizens that this is not being held in the government database?
Could you repeat the question?
Yes, with respect to all this data that's being obtained, are there any constitutional protections or remedies for innocent citizens that the government is not holding this in a government database?
According to Google's privacy policy, Google will share this information with the government if they have a good faith belief that it's necessary to enforce a legal request or a law. And this applies to the constitutionality of the issue because even if in a certain other situation like Carpenter, the government cannot request that information with too general a warrant, Google has specifically provided that they will share that information not on a constitutional basis, but on Google's own decision-making and Google's own discretion when they feel they have a good faith belief to share the information with the government. So if Google believes that this was necessary to help the government enforce the law, and Google states outright that their terms of service include complying with laws and not using items such as phones in the commission of crimes, and then in the terms of the privacy policy states they will share data if it's necessary to enforce the terms of service, the petitioner has no right to assume that their location is kept private when they have agreed to these terms of service and this privacy policy that states that that location information will be shared with the government if Google believes that there's a good faith reason to do so.
Go ahead. If an individual has especially unpredictable habits, is there no limit to the amount of data that can be collected? Because to your definition, encyclopedic knowledge or data would be enough to demonstrate habits of the person.
In this case, 2 hours would not be enough to demonstrate erratic habits or even the most unpredictable habits, or to create a detailed and encyclopedic record of how people move. Regardless of what their scope of their habits is, 2 hours is not a reasonable amount of time to determine an encyclopedic record of their movements.
How many hours?
That's not a specific number that can be determined, but here, for people visiting the locations within the radius, specifically the bank, a person does not visit a bank multiple times within 2 hours and have a habit as such. Since a warrant then gives some discretion to law enforcement officers as to how to process and narrow down the given information, and because of Google's privacy policy and Virginia Code 19.2 to 70.3, the warrant was valid in all three of the steps. Overall, the satisfaction of the probable cause and particularity requirements, as well as the validity of the warrant through the entire term, wholly and completely justify the lower court's ruling. For the foregoing reasons, respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the Fourth Circuit.
Thank you, Counselor.
Madam Chief Justice, may it please the court, my name is Sally Carbone, and I'm representing the Virginia Law Enforcement Association as amicus in favor of the respondent, United States, and respectfully request this court to affirm the decision of the United States Court of Appeals for the Fourth Circuit. This case turns on three key principles. First, that geofence warrants satisfy the Fourth Amendment's requirements of probable cause and particularity. Second, that the data obtained here was voluntarily shared with a third party. And third, that a categorical ban on geofence warrants would undermine lawful and essential investigative practices. We are here today because petitioner Okello Chattree, who robbed a credit union at gunpoint and was identified through law enforcement's use of a geofence warrant, is asking this court for a categorical rule that would establish all geofence warrants as unconstitutional. That rule, however, is unwarranted. The Fourth Amendment has never mandated blanket prohibitions on entire categories of investigative tools, but instead requires thorough case-by-case analysis. A complete ban of geofence warrants would undermine the use of critical resources that are necessary to law enforcement in the rapidly changing world of technology. Geofence warrants are judicially supervised tools that allow law enforcement to gain location history data from third-party providers within a defined time frame and geographic parameter. They are anchored in traditional warrant requirements as a magistrate reviews an affidavit, determines probable cause, and imposes clear limitations on the scope of the warrant. These warrants are not general, as some may argue, but instead specifically tailored to a precise location in a defined time window with a particular investigative objective, and it often employs greater precision than many traditional investigative methods. The warrant in this case was limited to a 150-meter radius surrounding the crime scene and a short time frame tied directly to the robbery, ensuring a clear nexus between the place investigated and the crime at hand. Additionally, geofence warrants employ a structured, multi-step process that ensures there is no unreasonable intrusion upon one's privacy. Providers begin by returning anonymized device data to investigators who then narrow down the data set based on relevance to the crime. Only after that process is any sensitive information disclosed. This tiered approach constrains government discretion and minimizes the exposure of information belonging to innocent individuals. Furthermore, Chattree consented to Google storing his location history data by opting into that feature of the software, as there has been a long-standing precedent in this court that individuals have no reasonable expectation of privacy in the information that they willingly provide to third parties. For example, in Smith v. Maryland, the court held that individuals have no reasonable expectation of privacy in the numbers that they dial because they knowingly share that information with a third-party phone company, similarly to how Chattree knowingly consented to his location data being shared with Google. Lastly, from a law enforcement perspective, geofence warrants are often the only tools that are capable of generating leads when suspects are unknown and all other traditional methods fail. For instance, in a Michigan homicide case that involved a victim found beaten and strangled in a remote area, investigators had gone without any leads until implementing a geofence warrant that revealed a single device present at the location of the crime. Based on the evidence found directly as a result of that geofence warrant, investigators were then able to identify a subject who was responsible for the murder. Similarly, in a cold case stabbing investigation in Georgia, a victim was found dead in his home. Despite a 911 call, investigators had no suspect or viable lead for months. Only after law enforcement obtained a geofence warrant did they identify a device present at the scene and time of the crime. Without the warrant, the killer would have never been identified and convicted of the murder. Cases like these prove that geofence warrants are necessary in solving a multitude of crimes that otherwise would remain unresolved. As a result, a categorical ban on geofence warrants would force law enforcement to rely on less effective investigative methods that would severely undermine overall public safety and the ability of investigators to find accurate evidence when solving the crime. For the foregoing reasons, amicus respectfully requests that this court affirm the decision of the Fourth Circuit.
That concludes our proceeding. Thank you. Please keep your seats.
congratulations to all our lawyers tonight. Your outstanding performance here ensures that the justices have a hard decision ahead of them.
On behalf of all the students and faculty who made this event possible, we thank you all for coming out tonight. Please have a great rest of your week.